Hi, this is Brian at Benglass Law. I'm a personal injury attorney in Fairfax, Virginia, specializing in auto accident cases. And one of the questions that we get a lot is, you're a contingency fee lawyer. I only have to pay you if I win my case, right? And the corollary of that is, all right, well, what happens if I lose? Like, how do you get paid? Do you get paid if I lose my case? And the short answer is no, we don't get paid if we lose a case. If we don't recover any money for the client, then we don't make any money. Which is why we, and frankly almost all personal injury lawyers, are very, very selective about the kinds of cases that we take. Right? We can't take risky small cases because the risk of doing a lot of work and bringing a case all the way to trial and not getting paid for the year or 2 years that you might be working on a case is too great. So you can take secure small cases, you could take secure big cases, you could take risky big cases, but you don't take risky small cases because the opportunity for you to not get paid for a year or 2 years of your work is just too large. It used to be the case in Virginia that you had to repay your attorney's costs if you lost the case. Even if you lost the case, your attorney couldn't put into his contract, I'm going to waive my costs if we lose it, right? And costs in a civil case are a filing fee, costs about $300 to file a lawsuit, deposition transcripts, depending on how many depositions you take, it's usually $300 to $700 per deposition to get the transcript together, depending on the length of the deposition, number one, and then of course how many parties are we going to depose, number two. And the largest costs in these cases are paying your doctors to come and testify for you. It can be several $1,000s. It used to be the case that lawyers could advance those costs during the course of the litigation, but were ethically bound to charge the client with those costs at the end of the case, right? We could not say, I'm taking a stake in the litigation, and client, if we spend $10,000 and we lose your case, you don't owe me anything back. That rule changed a couple of years ago, and so now it's up to the individual law firm to say whether or not they're going to waive those costs at the end of the case. My practice is that we have to have that conversation with the individual client, and it goes along with risk, right? I generally am happy to risk losing and not getting paid for my time on a large enough case. I'm less happy to have also invested money and have lost dollars having tried a case, right? And so it's a conversation with the client about, can you pay half the expert fees? Can you pay all of the expert fees? And depends on the case, right? In a more secure case, in a rear-end auto accident where there's virtually no chance that you walk away with no dollars, we're probably not going to have that conversation. But if it's a riskier case, if there's a chance that we might lose, and I've had conversations with clients and said, listen, we go to trial on this case, 25% chance that we walk out of here with $0, starts to make the offer look more appealing. And if the client doesn't want to take that offer, we start having a conversation about, well, I've got some personal risk in this too, because I've invested $5,000, $7,000, $10,000, and a need for you to start subsidizing the costs. If I'm going to be taking all the risk and you're the one making the decision about going to trial or not. Because at the end of the day, it's always the client's decision whether or not we accept an offer. I don't have any control over that beyond my advice that I give to the client. I can say all I want. This is a good offer. This is better than a jury is going to give you 90% of the time. And the client can say, I want to go and swing the bat. And so, whether you will never in a personal injury case owe your lawyer fees for his time if you lose the case. You may owe him back for his costs if you lose the case. And that's a discussion that's an ongoing discussion with the client and with the lawyer throughout the course of the pre-litigation and then litigation and right up until trial.